Hi, this is Hassan, and now I'm going to answer my question. The situation of Jack Scott and Tabitha Smith requires in-depth analysis of the English law of surrogacy arrangement, which is dependent on two parliamentary acts such as Surrogacy Arrangement Act 1985 and Human Fertilization Act 2008. The Surrogacy Arrangement Act 1985 states about what a surrogate is and which woman qualifies as a surrogate and clarifies the definition of the legal mother of the child born through the artificial method and surrogacy arrangement made based on money arrangement. The first issue is that Jack and Rita were most concerned about who would be the legal mother of the child at birth. The answer to this issue depended on Human Fertilization Act 2008, which Section 33 states that the definition of the mother, which is that the legal mother of the child would be the woman who bears the child by the aid of placement of the embryo or sperm in her uterus. The section illustrates that her Rupa bore that the child as the sperm of Jack was placed in her uterus, which resulted in the child. It can be understood that according to Section 33, Rupa is the legal mother of the child at birth. And the second issue is which concerns Jack and Tabitha, which other options they have other than adoption to become legal parents of the child, and what formalities are required. Jack has to find out who the legal father of the child is. The Section 36 and 37 of the Human Fertilization Act 2008 states the meaning of legal father of child. It affirms that at the time when the embryo or sperm and eggs were placed in W, or W was artificially inseminated, the agreed fatherhood conditions as set out in Section 37 were satisfied in relation to a man in relation to treatment provided W under the license. Then, subject to Section 38, subsection 2 to subsection 4, the man is to be treated as the father of the child. This all signifies that when a surrogate is married, her her husband mechanically becomes the father of the child, and in the situation when the surrogate single mother planned father whose sperm is used becomes the legal father of the child. Therefore, according to Section 36 and 37 of the Human Fertilization and Embryology Act 2008, it can be observed that Rupa is a single person and the planned father whose sperm is used conceiving the child is Jack. Consequently, Jack would be thought as the legal father of the child. Jack would have to represent himself as a registration office at the birth of registering himself as father of the child. As Sabita has not given birth to the child, she is not technically legal mother of the child. Legal mother of the child. To acquire this title, she has to go through the core procedure, which is that she has to get parental order. She has to firstly qualify for the application to the parental order. For applying for the order are very simple and can be fulfilled without any problem. The first condition is that intended parents should be above age of 18 years old, which is Tabitha and Jack qualify. Second is that intended parents should be married or civil partners. In case of Jack and Tabitha, they are civil partners, meaning they are living with each other as parents for a long time, as partners for a long time. One of the intended parent is also legal parent of the child. Jack fulfilled this condition. The next condition is that intended parents should be citizen of UK, which again Jack and Tabitha fulfills. The intended parents have opt for an artificial method of the procedure for the birth process of the child, which was carried by a licensed clinic. Jack and Tabitha have done that. The intended parents have full intention to brought up the child in their house. They intended to brought up the child in their home. After the completion of all the methods, Jack and Tabitha will be given permission to apply parental order, which time will start from the birth of child to 6th month age of child. They also have to acquire the written permission of Rupa, and she relinquishes her legal right of motherhood and claims to give them child legally. The legal formality would be Tabitha has to fulfill forms C51 and others to admit in family proceeding code. After the procedure, she will be given parental order, in which in turn will lead to issue birth certificate, in which Jack Tabitha will consider the legal parents of the child. The last issue that concerns Jack and Tabitha, as if Rupa refuses to give child back, will they be able to enforce the surrogacy agreement, and what alternative methods other court proceedings they can opt. It has been observed that UK law does not recognize any surrogacy arrangement, especially arrangement involving money with it. Section 1 subsection 3 Surrogacy Arrangements Act 1985 states the meaning of surrogacy as an arrangement is a surrogacy arrangement if a woman to whom the arrangement relates carry a child in pursuance of it, she would be surrogate mother. Section 1A of the Surrogacy Arrangements Act 1985, inserted by Section 36, subsection 1, Human Fertilization and Embryo Act 1990, does not implement any surrogacy arrangements in England and Wales. Section 2(1), subsection 2 of the Surrogacy Arrangement Act 1985 states that no person shall, on a commercial basis, do any of the following acts in the UK: that is, initiate any negotiation with a view of making surrogacy arrangement, take a part in negotiation with a view of making surrogacy arrangement, offer or agree negotiate to making surrogacy arrangement, or compile any information with a view to its use in making or negotiating the making a surrogacy arrangement. And no person shall be in you can knowingly cause another to do any those acts on commercial basis. A person who controverses subsection above is guilty of an offence. Therefore, this act can make it an offence to make and negotiate a surrogacy arrangement on commercial basis, meaning that pursuant to section 2 of the Surrogacy Arrangement Act 1985, it means that if you start making it a business, it will be an offence. The parties have to show their court this surrogacy arrangement was not based on commercial surrogacy arrangement. Jack and Tabitha does not have to fear, as they have made a commercial surrogacy arrangement. That's why they have not been held liable under the offence. There have been circumstances when surrogates refused to give the child to intended parents. This was the case in Re P, because of which Baker J created a residence test to find which party will be suitable brought up the child. The test is based on criteria which distinguishes parent will be able to give financial support, emotional support to the child. Moreover, Baker J illustrated that surrogacy arrangement is full of risk and is difficult to solve this problem. However, conciliation is a voluntary proceeding where the parties involved are free to agree attempt to resolve dispute by conciliation. The process is flexible, allowing parties to define the time, structure, and content of conciliation proceedings. These proceedings are rarely public. These are interest-based, as the conciliator will, when proposing a settlement, not only take into account the parties' legal positions but also their commercial, financial, or personal interests. Therefore, it would be better to opt mediation or conciliation. Thank you. My BP number is BP 057763. Thank you very much.